Hey class, it's Mr. Stewart, and this is going to be the integrity video for week 3, which is chapters 4 and 5 here for Intro to Criminal Justice. So I'm a little bit late getting that integrity video uploaded to you this week. It's just been a really hectic week, and I don't really have an excuse other than the fact that I just didn't get a chance to do it until now. But anyway, I want to talk to you for a few minutes about a few things that's in chapter 4, and then move on into chapter 5 and talk to you for a few things that's in chapter 5, hopefully to clear any muddy waters that you may have after looking and reading those chapters at this point. So chapter 4 has to do with being inside criminal law. And one of the things that our legal system in the United States is based on is something called the doctrine of precedent. This slide that you should be seeing here says, explain precedent and the importance of the doctrine of stare decisis. And that, basically, the doctrine of stare decisis is the doctrine of precedent. And what stare decisis means is to stand by decided cases. So basically what it means is that we don't have to reinvent the wheel every time somebody goes to trial and makes an issue out of something. We can go back to previous cases in which similar issues were raised, and then we can look at the way that the judge decided in those cases, make a determination whether that is applicable to the current case, and if so, the judge will make a decision on the current case with regard to that case law that was generated from an earlier case. And basically, it saves a lot of time and a lot of effort. We're one of the only countries that uses this idea of stare decisis, and it allows us to maintain kind of a cadre, if you will, of case law as to how our courts have decided on similar issues in the past, so that everything is not such a chore in the court system. So hopefully that makes a little sense. And I want to talk for just a minute about the written sources of American law, basically where we get law from. We get law from our Constitution. You should be aware of that. Constitutional law has to do with those things that are written in the articles of the Constitution, as well as in the amendments that specify what rights people have and how certain procedures should be done. Then at the state and federal levels, we also write statutory law, and that is basically law by statute. And statute simply is a written law promulgated by a legislator at the state level or the federal level that says certain behaviors are criminalized and what the particular punishments for them are. It's much more specific than constitutional law is. Constitutional law, if you will, is the framework. The statutory law then fills in the gaps within that framework. And then I'm going to go ahead and move on to number 4 here, then go back to number 3. Number 4, another source of law in our system of justice is case law. And that's what I just got through talking about. Those are those court decisions that have been handed down previously, so that we can use them as guideposts, if you will, for current court decisions. And these 3, constitutional law, statutory law, and case law, I think you can understand fairly easily how that is considered sources of our law in this country. Now this last source, called administrative law, is really honestly not law, but it carries with it almost the same power and authority as a law does. So the issue with administrative law is that it's not been done, it's not been promulgated or built or put together, if you will, by those people who have been elected into office, which is the way law should be put into place. But it is administrative law is simply rules and regulations created by agencies, either at the state level or the federal level, that kind of show how those agencies are supposed to operate, and will also allow them to punish people if they violate some of those regulations. For example, if you aren't making clean food, or your food is contaminated and you own a food manufacturing business, then you fall under the rules and regulations of the FDA or clean drugs. Some of you may remember several years ago there was an issue with some sort of cortisone injections that were given to people with back problems, and it was infected with a fungus that caused meningitis in several people, caused several deaths, and caused a lot of paralysis and things of that nature. And it all came from an unclean drug manufacturing facility up in Massachusetts, I believe, or Connecticut, somewhere up in there. And the rules that govern that were promulgated by the Food and Drug Administration. The Environmental Protection Agency, EPA, is a big one for administrative law. There really aren't very many federal criminal laws that EPA uses, but they have a whole host of regulations that they enforce, and they will punish you if you violate those, and punish you fairly severely, by the way. So we have, in essence, allowed agencies to make rules and enforce those rules as if they were law, and when in fact they're not law, but they carry almost the same power and authority as the law does. And by virtue of allowing that to happen for a while, it's going to take a while to get away from that. So we do consider administrative law a source of criminal law here in this country. And the law has two basic functions, and this is important. The first basic function is the legal function of the law, and it protects and punishes. So what it does is it maintains social order by protecting its citizens from criminal harm. So it will protect those people who are not law violators, and it will punish those people who are law violators. And this includes harm that is caused both to individual and even in society, harm to society as general, because not every crime that we have actually has a specific human victim. It may simply be that that's an offense against society, an offense against the public, if you will, and if we allowed it to continue, it could cause harm to society and make us less cohesive and more prone to society breaking up, or at least regressing from our current point. So not every crime has a specific victim, but when a crime does not have a specific victim, then society or the state, etc., is considered a victim. Now the other function of the law is the social function. And that function of the law serves to maintain and teach. And what that does is we pass a lot of what we know about the law down through TV, down through conversations with other people. I mean, most people don't have a legal education, but by the time you graduate high school, you have a pretty good understanding of what you can and cannot do in society, and what's illegal and what's not illegal. And so that's the social function of the law, is that when some people know about it and we make public how we enforce it, then that serves as a teachable moment, if you would, to the rest of society. And the law is also an expression of public morality. So if typically the law is promulgated by the consensus of the people within that society, which means that whatever law is out there is basically the opinion of the society at the time that law was passed. Understand that may change from time to time, and as the public sentiment changes or the public opinion changes on something, but the law is supposed to be the expression of public morality and teach us social boundaries within society, those boundaries of what is acceptable or not acceptable. Please read in your textbook here the elements of mens rea as well as actus reus, basically the criminal act, along with the criminal mindset, and that those things must occur together before you actually have a crime. So somebody has to do something that's a crime. You have to have meant to do it, or you should have known that it was a crime. And then those things have to happen together. And if those elements are met, typically you have met the conditions required in order to consider that behavior criminal and punishable under our law. So with that being said, make sure you read that section and make sure you reach out to me if you have any questions. Also understand that not every crime requires intent. Some things, just the act, just because you did it, is enough to get you convicted. And that's what we call strict liability offenses. Just because you did something, we don't have to prove you meant to do it. You can still be convicted of it. And an example is speeding. We don't have to prove that you meant to speed in order to convict you of speeding. All we have to prove is that you were speeding. Now understand, we don't have a lot of strict liability offenses that are very serious offenses. It's typically on the lower end of the spectrum. But we do have some offenses out there in which we do not have to prove intent. And it's also important to understand that in this country, if you are an accomplice to a crime, whether you knew about it prior to the crime happening or you knew about it after the crime had happened and you reported it neither time, you can be charged with the same crime as an accomplice. So that's what we call accomplice liability. You can be charged with crimes you did not actually commit if you acted as an accomplice in some shape, form, or fashion. Please read that section on corpus delicti, which is basically the body of the crime, all those other things that we include to be parts or elements of a crime. The rest of this chapter goes into talking about defenses. Read those things. It is a defense to a criminal act if you were too young to know better, if you were insane. It is typically not a defense if you were intoxicated, unless the intoxication was involuntary. And what that means is if somebody drugged you, you're not responsible for your actions. But if you intentionally got drunk or took drugs, you are responsible for what you do while you're under the influence of that. And mistake is typically not a really good defense to crimes. It doesn't, which means you can't say, well, I didn't know that was against the law, or I didn't mean to break the law. It depends on what the crime is. If we don't have to prove the intent, then you're probably going to get convicted even if it was a mistake. But we do have the ability in our justice system to give people a pass and hold them less culpable for their criminality if they in fact engaged in a criminal offense because of a mistake. So just understand that's out there. It's also pretty rare. We don't use it very often. We also have justification defenses, such as duress, which meant you were under duress. You were almost forced to commit a crime. Self-defense. That's when you're protecting yourself or others. That is also a defense to crime. Necessity, which means you had to do something that was considered criminal in order to maybe protect the life of someone else. And then, of course, entrapment. This is a popular one, especially in drug arrests. This is where the defendant claims to have been induced by the police to commit the act that they normally would not have done. It's claimed a lot, but it's pretty hard to prove, by the way. And we have to look at a totality of the circumstances to see if the police actually almost induced or forced you to commit the crime. And if they didn't, then that defense isn't going to work. Marine Detective 8 in this chapter looks at the difference between substantive law and procedural law. Substantive law is the law that defines the acts that the government will punish, and then the procedural law basically says how we're going to do that. So the substantive law is like a state law that says it is a violation of state law to kill somebody. That's a substantive law. And a procedural law says if you were charged with murder, here's how we will go about sending you to trial, getting the evidence admissible in court, finding you guilty, and then subsequently punishing you. So it sets forth the procedures necessary in order to punish somebody of a criminal act. And of course, due process is important. Basically, what I want you to understand about due process is that you should equate it with the phrase fundamental fairness. And you are entitled to due process both in procedure and in the interpretation of the law, which means we should treat people fairly and equitably in the criminal justice system, no matter what their crime is. And what I mean by that is you are entitled to the same protections in the criminal justice system no matter if you stole a piece of peppermint candy from the Shell station or you hacked your mother to death with a butcher knife. And that's basically what due process, the protections are. So please read that section as well. That's all I really wanted to cover out of this chapter. Again, you have to read the chapters and you have to get into this material and start trying to understand it. But that should clear up some of the muddy waters possibly. Now I want to talk for just a few minutes here about Chapter 5, which is law enforcement today. And with all of the recent bad publicity in regard to policing, everybody's has got their opinions about how good a job police are doing or not doing, and what acceptable police behavior is. I'm going to challenge you to not rush to judgment on police officers. Don't judge me until you've walked a mile in my shoes, because it's a very hard job, and right now they just happen to be in the public eye, under public scrutiny because of bad media reporting, not necessarily because of bad police conduct, but bad reporting of good police conduct has really changed the public sentiment in regard to policing right now. So there's some major issues that policing is having with its image as well as with its job and expectations by the public. So again, please read this chapter. I think you'll find it pretty interesting. But I think it's important you understand what the responsibilities of the police are. And most people don't understand that there's more to the police job than simply enforcing the law. That's really only a fairly small part of what police officers do. They spend a fairly small portion of their workday enforcing the law. They also provide services, they prevent crime, and they're there to preserve the peace. So the simple act of them being there, patrolling neighborhoods, being visible, helping people when they call and need help for this, really does those things 2, 3, and 4 here. Only a small portion of the police officer's day is actually spent enforcing the law, but that is probably the most public part of policing. That's when the media likes to film us, or people like to film us with their cell phones, is when we're out there actively enforcing the law, which is a very difficult job. And I would suggest to any of you to go participate in a police ride-along with HPD or Decatur PD or Athens PD or Madison County Sheriff's Office or Morgan County Sheriff's Office, and before you rush to any judgment in regard to what the police do. I think it would be an enlightening experience for you. Now, this chapter also kind of goes into the history of policing in this country, and the best way I can sum up the history of policing is that we started out bad and we got a little bit better. Initially, law enforcement was very unprofessional, uneducated, it was low paid, and very highly susceptible to corruption here in the United States. For the first 100 years of policing, from 1840 to almost 1940, actually about 90 years, from 1840 to about 1930, policing in this country was rife with corruption. We had the best police that political money could buy. Seriously. It wasn't until the creation of the International Association of Chiefs of Police, the creation of the Knapp Commission, the Wickersham Commission, where we really began to try to clean up policing and move it from a vocation into a profession, in which we actually want the people who work in policing to have a professional set of skills. And it is a destination job, not just a job that somebody does in order to pay the rent. You do it because you have a servant's heart, and you do it because you want to serve and you want to help people, and not because you want to drive fast, shoot guns, and think every day is your birthday and every meal's a feast, because it just isn't. So read that section on the history of policing in here. I think you're going to find it pretty interesting, and you're going to see that we started out very corrupt, and we have slowly begun to professionalize and get better. And there's also been kind of an up and down, a pendulum swing of the public's perception of the police from its inception until the present. You know, prior to the Ferguson incident, police were fairly highly regarded in this country. And now, because of bad media reporting of a police officer that did his job and did it correctly and did it well in Ferguson, and the way the media reported that, police have begun, or the public's begun to not really like the police. And so we're seeing a distance emerge between the public and the police right now, which to me is reminiscent of that distance that occurred when we took the police out of communities and put them in police cars in the 1930s and 40s while we were trying to get rid of corruption. It worked really good to rid the police of corruption, but it worked really bad to keep the public and the police on the same page. And we've been really fighting, trying to get back in line with being in agreement with and get cooperation with the public since 1940. So that's just kind of where we are right now. So read about those eras in policing, the Wickersham Commission. Read about intelligence-led policing, the difference between the police academy and field training. You know, basically the academy is where you go to get a basic set of skills necessary to survive on the street. But field training after the academy is where you learn how to be the police. There is no substitute for field training. You have to have good field training or you will not make it as a police officer. You can go to the academy all day long, but you'll find out that the academy doesn't always, the field doesn't always work like the academy does. So keep that in mind as well. This last part of the chapter goes into some of the challenges that are facing people in certain people or groups in law enforcement right now, such as women. It is becoming a more popular profession for women to get into, much more popular than it's ever has been. And then the chapter goes on to talk about some of those federal agencies and the Department of Homeland Security. All that's really straightforward. Please read that. Again, if you have any questions, reach out to me. And then the last part of the chapter talks about the connection between private security and policing. So I don't want to get too deep in this lecture, but I want to make sure that you read this information and that you're paying attention to some of these important parts. Anyway, that concludes our integrity video for this week, and I'll try to get it posted earlier than this day of the week for next week. Anyway, for chapter 6 and 7, or 7, 8, whichever it is that we're on. That's going to be chapter 6 and 7. Yeah, because we did 4 and 5 today. Again, if you have questions, reach out. I'm here for you. I'll be responding in discussions, get grading done over the next several days. And I'll see you soon. Bye-bye.